Okay, let's unpack this. We're about to take a deep dive into a case that feels ripped from the pages of history, really, even though its legal conclusion is quite recent.
Yeah, it's a fascinating one.
This is the story of Robert Van Gestel, a case that began with quiet allegations reaching back decades, back into a suburban Sydney past.
But it didn't stay quiet, did it? It ended up in these high-stakes battles in the top criminal courts in New South Wales.
Exactly. And this deep dive, it's built entirely on the source material you shared with us, so court summaries, legal documents.
The paper trail itself.
Our mission today is really to follow that trail, to try and understand this complex legal saga, map out the dramatic turns,
See who was involved at each stage, the lawyers, the judges.
and trace that specific procedural path justice took, years and years after the alleged events,
It's a really powerful illustration, I think, of how the past can suddenly catch up.
and how the legal system has to grapple with these immense challenges, especially with allegations from childhood surfacing so much later.
Definitely. It's not just a case file, it's a story with distinct chapters and a really interesting cast of legal characters.
So let's begin by setting that initial scene. We're not even in a courtroom yet. We're in a residential cul-de-sac, Forestville, suburban Sydney.
Yeah, picture it. A typical quiet neighborhood, probably neighbors knew each other, that sort of thing.
And the alleged events at the heart of this case, they span a really significant period between January 1974 and January 1994.
A 20-year window.
And the core of the case involves serious allegations made by 3 female complainants. Now, the sources use pseudonyms Amanda, Bertha, and Caroline to protect their identities.
Which is standard practice, of course.
Let's detail those allegations because they really set the stage for everything that follows. Amanda. She was a friend of one of Van Gestel's daughters.
Right, and she was the complainant in 5 counts of indecent assault.
And these were alleged to have occurred between January 1974 and June 1977, a time when she was just incredibly young, 5 to 9 years old.
And the alleged acts were very serious.
They were. Intimate touching over and under clothing, digital penetration, both vagina and anus alleged, and 1 count where she alleged Van Gestel forcibly placed her hand on his erect penis.
And crucially, these all allegedly happened inside his home.
Inside the home. Then there's Bertha, born in 1982. She was the complainant in 2 counts.
The first was an indecent assault, alleged when she was about 6, a kiss on the lips.
Right. And the second, described as aggravated indecent assault, was alleged when she was between 9 and 11. A prolonged kiss on the lips, apparently after she'd just come over to barrow eggs.
Simple neighborly thing becomes something else entirely in the allegation. And again, inside his home.
Inside his home. And finally, Caroline. Bertha's younger sister, born 84. 1 count of indecent assault against her.
This was alleged around August-September 1989, when she was 4 or 5.
She testified about going over to buy a beer for her father, and Van Gestel allegedly kissed her on the lips, saying it was for a real kiss.
And again, the same location, his home.
So that's the chilling common thread, isn't it? All these alleged acts happened within the supposed safety of Van Gestel's home, a place these young girls were visiting.
What immediately jumps out, obviously, is the huge time gap.
Decades. We're talking decades between when these events allegedly happened and when the complainants eventually disclosed them.
And this is that critical challenge you always see in historical cases like this.
Yeah, while it's unfortunately common for survivors to disclose years later, it creates massive legal hurdles. Memories fade.
For everyone involved, potentially.
Right.
Complainants, the accused, and physical evidence. Virtually non-existent after that long.
And a key issue that became really fiercely contested, especially later in the appeal, was this complaint evidence.
Meaning who these women told about the alleged abuse, and really importantly, when they told them.
That long shadow of the past lingered for so many years before the legal system formally got involved.
The formal legal process actually began relatively recently, February 10th, 2020. That's when Robert Van Gestel was arrested.
Right. And then extradited from Victoria back to New South Wales to face these charges.
And just the very next day, February 11th, 2020, he was granted conditional bail.
Initial conditions were pretty standard for something like this, I suppose. Reside at a specific address down in Victoria.
And no contact with prosecution witnesses, including a couple of named individuals, unless it was through lawyers.
And this is where we start seeing the legal teams properly form up, while the sources don't name counsel for that very first bail application.
McCanny lawyers are consistently documented as his defense solicitors, right through the whole thing.
They were. And on the prosecution side, It was the Office of the Director of Public Prosecutions, the DPP, handling the case for the state.
It's quite notable, actually, that Mr. Van Gestel remained on bail for over 2 years.
From February 2020 right up until June 2022, after the conviction.
That length of pretrial liberty isn't necessarily unusual for really complex historical cases. They take time to prepare.
But in this specific instance, it definitely set the stage for a pretty dramatic shift in his legal status later on.
And that shift came right after the trial phase in the District Court of New South Wales.
The trial took place before Judge Latham, SC ADCJ.
SC being Senior Counsel, ADCJ, Acting Deputy Chief Judge. So a very experienced judge.
Absolutely. And the jury faced this incredibly difficult task, didn't they? Weighing testimony about events alleged to have happened decades before.
You can only imagine the atmosphere in that courtroom must have been highly charged.
The sources tell us the core of the Crown's case really rested on the testimony of the three complainants, Amanda, Bertha, and Caroline.
Them recounting their experiences decades later. Powerful stuff, no doubt.
And in his defense, Robert Van Gestel himself took the stand, gave evidence under oath.
And issued a categorical denial. Denied every single allegation made against him.
So, as the appeal judgment later put it, the trial was essentially a black and white contest.
A direct clash of narratives. Completely opposing stories. It really came down to who the jury believed.
And on June 9th, 2022, after hearing all the evidence, all the arguments, the jury delivered their verdicts.
Robert Van Gestel was found guilty on all 8 counts.
Guilty on all counts. The key players in the courtroom during that trial: Judge Latham, SC, ADCJ, presiding.
For the Crown, a prosecutor from the DPP, the specific name isn't in the trial source, but we know Gene Newton appears later for the Crown.
Right. And for the defense, the barrister was Mr. Chaudin, instructed by McCanney lawyers who, as you said, remained his solicitors.
Now, what happened immediately after the verdict was, well, a bit surprising in hindsight.
It was. The Crown didn't immediately apply for Mr. Van Gestel to be taken into custody, which can often happen right after a guilty verdict for serious charges.
Instead, the trial judge allowed him to remain on his existing bail conditions.
And a sentencing date was set for several months down the track, October 21st, 2022.
Now, this decision allowing bail to continue post-conviction came under scrutiny later, particularly around how the defense counsel, Mr. Chaudin, handled that complaint evidence during the trial.
Remember, that's the evidence about when the complainants first told someone about the alleged assaults.
The source material points out that Mr. Chaudin didn't actually object when the Crown presented this evidence early on, what's called in chief.
Yeah, and the appeal judgment later mused about this, suggesting Mr. Chaudin might have seen a forensic advantage.
Meaning, maybe he thought he could use the delay in the complaints to attack the complainant's credibility when he cross-examined them? A tactical choice, perhaps?
A calculated risk, maybe.
Yeah.
But this handling, or perhaps lack of objection, regarding the complaint evidence at trial, it absolutely laid the groundwork for a central argument in the later appeal.
It really shows those high-stakes decisions trial lawyers have to make.
So, with those guilty verdicts in, Robert Van Gestel's legal position changed dramatically.
Yeah.
That presumption of innocence, gone.
And here's where it gets really interesting, legally speaking. A major new law came into effect right on the heels of the conviction.
Perfect storm, almost. This new law, combined with the fresh conviction, set the stage for a really fierce legal battle over his liberty.
Just weeks after Van Gestel was convicted, June 27th, 2022, Section 22B of the Bail Act 2013 in NSW became law.
And this was a genuine game changer, wasn't it?
Absolutely. Section 22B was specifically designed to make it much, much tougher for convicted offenders awaiting sentence to stay on bail, especially if they're likely facing full-time prison.
Under this new section, bail must be refused unless the offender can prove special or exceptional circumstances exist.
It raised the bar significantly, a much higher hurdle to clear.
And armed with this powerful new legal tool, the Director of Public Prosecutions, the DPP, moved very swiftly and aggressively.
Act 1. The Supreme Court showed down the DPP's first strike. On June 17, 2022, this is before S22B was even officially active, but clearly anticipating it, the DPP filed an application to have Van Gestel detained, straight into the Supreme Court of NSW.
Quick off the mark. This application was heard by Justice Garling in the Supreme Court on July 19, 2022.
And the legal teams for this first post-conviction bail fight really show the stakes. Justice Garland presiding. For the DPP, seeking detention, counsel were Gene Newton and R. Kotsis, instructed by the DPP's office.
And for Van Gestel, fighting to stay out on bail, His counsel were M. Hobart, SC Senior Counsel, and T. Hennedy, still instructed by McCannity lawyers. So senior counsel brought in for the defense now.
The DPP's argument was pretty direct. Given the convictions, especially for the serious counts involving Amanda, Van Gestel faced an inevitable sentence of full-time imprisonment.
Simple as that, from their perspective.
The defense team, led by Mr. Hobart SC, obviously countered this. While they had to acknowledge the guilty verdicts, they would have been emphasizing factors arguing against immediate detention.
Probably laying the groundwork for those special or exceptional circumstances arguments they knew they'd need under the new law.
But despite the DPP's push, on July 21st, 2022, Justice Garling delivered his decision. He dismissed the DPP's application.
Van Gestel remained on bail, though an extra condition was added: no unsupervised contact with kids under 12.
The detailed reasons came out the next day, but this was definitely an initial setback for the prosecution.
Yeah, it showed the courts immediately grappling with how to interpret and apply this powerful new Section 22B.
The DPP was quick, but the Supreme Court wasn't immediately convinced, at least at that stage, that the threshold for denying bail was met.
Act 2. The Court of Criminal Appeal decides the tide turns. But the DPP was absolutely determined. They didn't just accept the Supreme Court loss.
No way. On July 27th, 2022, just 6 days after Justice Garling's ruling, they lodged a further detention application.
This time going directly to the Court of Criminal Appeal, the CCA, under a specific part of the Bail Act, Section 50.
And crucially, this wasn't just asking the CCA to find an error in Justice Garling's decision. Section 50 allows the CCA to conduct a completely new hearing of the bail application itself, a fresh look.
The stakes were incredibly high now, and the CCA hearing happened fast August 1st, 2022. Before a panel of 3 senior judges, Gleason J.A., Wright J., and Kavanaugh J., meaning judges appeal.
The legal teams were largely the same heavy hitters from the Supreme Court battle. G. Newton and R. Kopsis for the DPT.
And M. Hobart SC and T. Hennessy for Van Gestel, still instructed by McCannity. Consistency there.
And the whole legal fight in the CCA boiled down to 2 critical questions under that new Section 22B.
First, could the court be satisfied that Van Gestel will be sentenced to imprisonment to be served by full-time detention? That word "will" was key.
And second, if the answer to that was yes, had Van Gestel managed to prove those special or exceptional circumstances needed to get bail anyway?
Mr. Newton for the Crown argued really strongly on that first point. He said will didn't mean absolute 100% certainty, but rather a very high degree of likelihood.
He used the phrase realistic inevitability.
Right. And he argued that given the objective seriousness of the convictions, especially counts 1 to 5 involving Amanda, a full-time prison sentence was practically unavoidable.
Mr. Hobart SC for Van Gestel had to acknowledge the seriousness, but he countered by pointing to his client's personal circumstances, what lawyers call subjective factors.
His age, 78 at the time, recent health issues, including a TIA, his clean record before this, purported rehabilitation.
And he argued that an intensive corrections order, an ICO, which is served in the community, was at least theoretically available to the sentencing judge. It wasn't impossible.
Van Gestel's team also put forward specific arguments trying to establish those special or exceptional circumstances.
Yeah, they raised his significant health issues needing community treatment, they said.
The need for liberty to attend medical appointments to get reports for sentencing.
And the need for time to arrange care for his 74-year-old wife, who he was primary carer for, and their adult son living at home.
But the Court of Criminal Appeals' interpretation of S22B in this case, it became incredibly significant, decisive.
On that first question, will be sentenced, they agreed with the Crown. They said will required an evaluative judgment of what was realistically inevitable, not absolute certainty.
And looking at the seriousness of counts 1 to 5, the maximum penalties, even defense concessions, they were satisfied. Yes, he will be sentenced to full-time imprisonment.
Then, on the special or exceptional circumstances point, the CCA was very strict indeed.
They emphasized the onus was entirely on Van Gestel to prove it, on the balance of probabilities.
And they went through each claim meticulously. Health issues. Justice Health, the prison health service could manage it. Medical tests. Could be done in custody.
Care for his wife and son. They noted 7 weeks had passed since conviction, enough time to make arrangements. Plus, evidence suggested family support was available.
So they concluded these factors, individually or altogether, simply did not meet the high bar of special or exceptional circumstances under the new law.
And so the climax of this intense post-conviction bail fight arrived right at the end of the hearing on August 1st, 2022.
The Court of Criminal Appeal granted the DPP's application. Robert Van Gestel's bail was revoked on the spot, ordered into custody forthwith.
The full, detailed reasons came out later, August 12th, in the judgment Director of Public Prosecutions, NSW v. Van Gestel.
And that decision was hugely impactful. It became a major precedent, defining that realistic inevitability test for S-22B.
And setting a very stringent high bar for special or exceptional circumstances.
For Van Gestel, it meant a dramatic, sudden reversal. From liberty for over 2 years to incarceration in a matter of days.
It really raises that important question about the balance the system tries to strike between pre-sentence liberty and post-conviction detention, especially when new, tougher laws come in.
Yeah, it shows just how quickly things can change for someone once that jury delivers a guilty verdict.
So, with Robert Van Gestel now in custody following that decisive CCA ruling, the case moved to the next logical stage, sentencing.
This took place back in the district court before the original trial judge, Judge Latham, SC ADCJ.
The sentencing hearing was held on the date that had been set way back in June, October 21st, 2022.
On that date, Judge Latham handed down the sentences for all 8 counts.
For counts 1 through 5, those most serious charges involving Amanda Van Gestel received an aggregate sentence of 6 years imprisonment.
Aggregate meaning a total sentence reflecting all those counts together.
Exactly. And within that 6-year term, a non-parole period of 3 years and 6 months was set. That's the minimum time he has to serve before potentially getting parole.
And importantly, that sentence was backdated to start on July 29th, 2022.
Which acknowledged the time he'd already spent in custody since just before the CCA revoked his bail. Fair enough.
And that sentence clearly reflected the higher objective seriousness the court saw in those offenses, penetration, repeated abuse over time.
Right. But for counts 6, 7, and 8, the less severe charges involving Bertha and Caroline, the kissing allegations.
For those, he received a community correction order, or CCO, for 3 years, starting from the sentencing date itself.
So a non-custodial sentence for those counts, served in the community under supervision and conditions.
And this difference in sentencing is pretty standard. It likely stemmed from the significant variation in the nature and severity of the acts, the victims' ages, duration of others, all those factors judges weigh up.
Sentencing is always a complex balancing act. The sources don't name the specific counsel at sentencing, but it's inferred the same teams were likely involved.
Defense counsel from McCannany Lawyers Panel, and a Crown prosecutor from the DPP maintaining that continuity.
But despite the verdicts, despite the sentences being handed down, Robert Van Gestel wasn't finished. He decided to challenge his convictions.
He launched an appeal to the New South Wales Court of Criminal Appeal, the CCA. It's important to note, though, he didn't appeal the severity of his sentence.
No, just the convictions themselves. He was arguing the jury got it wrong.
And for this final major challenge, there was a notable change in his legal team, at the senior barrister level anyway.
While McCannany lawyers stayed on as his instructing solicitors, a new senior counsel, J. Stratton SC, was brought in to lead the appeal.
On the Crown side, though, consistency. G. Newton SC, who'd led the successful bail revocation fight and had since been appointed senior counsel, or taken silk.
He remained the Crown's barrister, now instructed by the Solicitor for Public Prosecutions, which is just the formal title for the DPP at the appeal stage.
The appeal was heard by another formidable 3-judge CCA bench, Leeming J.A., Davies J., and Wilson J., on September 29, 2023.
Van Gestel's appeal was based on 3 distinct grounds, 3 specific arguments for why the convictions should be overturned.
The first ground, and probably the most significant legal argument, was that the trial judge made an error in admitting the complaint evidence.
The argument was that evidence of complaints made decades later shouldn't have come in because it wasn't fresh in the memory under the Evidence Act.
And that it was basically inadmissible hearsay evidence.
This ground partly relied on an affidavit from his trial lawyer, Mr. Chaudin, suggesting he'd understood the judge had okayed the evidence before the trial really got going, so he didn't object later.
The second ground was described by the CCA as novel, meaning new, and importantly, it hadn't been raised at all during the trial.
This one claimed the jury needed a specific direction, that Van Gestel had to have a particular indecent intention, not just intent to do the act itself.
And the third ground was a fairly standard appeal point, that the guilty verdicts themselves were unreasonable.
Essentially arguing that no reasonable jury could have convicted him, given things like allege inconsistencies in the complainant's stories.
The fact they were testifying decades later about childhood events, the long delay before complaints, Van Gestel's own denial, and evidence of his prior good character.
The CCA, in a really meticulous judgment led by Justice Leeming, dissected every single one of these grounds and firmly rejected them all.
On the complaint evidence ground 1, they went through the trial transcript with a fine-tooth comb.
And they found absolutely no evidence the trial judge had ever made a final ruling before the trial that this evidence was admissible under the freshness rule.
Instead, the judge had called it premature early on, said it would be looked at afresh during the trial.
And crucially, had pointed out it might become admissible later under different rules, Section 108.3, if the defense suggested the complainants had made it up or colluded.
So the CCA said the trial judge wasn't obligated to jump in uninvited sua sponte when experienced defense counsel chose not to object, especially when there was another potential way for the evidence to come in.
Plus, they stressed the trial judge had given very clear warnings to the jury. Use this complaint evidence only for credibility, not as proof the assault actually happened. So, leave granted, but appeal dismissed on that ground.
Ground 2, the indecent intention argument. The CCA refused permission to even appeal on this point.
Primarily because it wasn't raised at trial, a huge hurdle on appeal.
But more fundamentally, they said the argument itself was legally wrong in NSW. It ignored binding case law saying indecency is judged objectively by community standards, not by proving the accused's subjective intent.
Plus, it mostly related to the non-custodial counts anyway, so limited practical impact.
And finally, ground 3, the unreasonable verdict claim. They dismissed this appeal ground too, although they granted leave to argue it.
They acknowledged the defense points, the delays, the minor inconsistencies like, details about a toilet's location decades ago.
But the court emphasized issues like that are inevitable and entirely expected in a case of this nature, given the huge passage of time.
These points were fully argued to the jury by the defense, addressed by the judge. It was the jury's job to weigh credibility and evidence.
And the appeal court found it was entirely open for a reasonable jury to be satisfied of guilt beyond reasonable doubt. Justice Wilson specifically added no significant possibility that an innocent person has been convicted.
So the final outcome, delivered on October 20th, 2023, appeal dismissed. Robert Van Gestel's convictions stood firm.
That final appeal phase really hammered home the very high legal bar needed to overturn a jury verdict in NSW.
Appeal courts are there for legal errors or fundamental miscarriages of justice, right? Not just to second-guess the jury on the facts.
Exactly. There's significant deference to the jury's view on who to believe and to the trial judge's management of the trial.
And that continuity of G. Newton SC for the Crown, from that crucial bail fight right through to the final appeal win, really highlighted the state's consistent, determined prosecution of the case.
So that dismissal of the appeal on October 20th, 2023, that really marked the end of the legal road for this case.
A journey spanning nearly 4 years from his arrest back in February 2020.
And traversing multiple levels of the justice system. District Court for trial and sentence, Supreme Court for that first bail fight, the CCA twice, once for bail, once for the conviction appeal.
Involved numerous lawyers, McCanney solicitors, DPP prosecutors, multiple barristers including SCs, and of course the judges at each stage.
For Robert Van Gestel, with his legal options exhausted, it means continuing to serve that sentence handed down by the District Court. The 6 years, 3.5 non-parole for the Amanda counts.
And for the complainants Amanda, Bertha, and Caroline, the conclusion brought, well, a form of finality, I suppose, after that incredibly difficult process of recounting trauma and navigating the system.
The validation of the jury's verdicts by the highest criminal court in the state is undoubtedly a significant outcome for them.
Beyond the individuals, though, the Van Gestel case has definitely left a clear legal imprint.
Yeah, if we connect this to the bigger picture, this case was a major early test, wasn't it? And a confirmation of those strict new S-22B post-conviction bail rules.
That DPP v. Van Gestel CCA judgment is now a key precedent. Defines realistic inevitability, sets that high bar for special or exceptional circumstances.
It also gave us detailed appellate examination of how complaint evidence in historical cases gets treated under the Evidence Act, Section 66 and 108.
And it adds to the case law on assessing unreasonable verdict arguments in these really challenging, decades-old allegation cases.
So what does this all mean for you, listening to this deep dive? I think it highlights the intricate way the legal system tries to balance these different sometimes competing interests,
You've got the fundamental presumption of innocence before conviction.
but also the protection of the community, especially after
And
convictions.
then this incredibly complex, often delayed pursuit of justice for alleged events that happened so far in the past.
We followed that paper trail on Robert Van Gestel's case, haven't we? From that suburban cul-de-sac right through every significant legal stage up to the highest criminal court in NSW.
It's a powerful reminder, I think, of how the past can unexpectedly catch up.
And how the law keeps evolving to try and address these really tough issues, like historical allegations and the challenges of memory across time. Not to mention the human dramas unfolding within that system.
What really stands out to you from this deep dive, listening along, is it the sheer drama of that post-conviction bail battle under the new law?
Or maybe the detailed legal arguments around memory and evidence that the appeal court had to dissect?
Or perhaps just the simple, sobering fact of the enormous amount of time that passed before this case reached its conclusion.
This case, like so many historical matters, really asks us to consider not just the alleged events themselves, but the long shadow they cast.
And the justice system's enduring, difficult quest to uncover truth and deliver accountability across time. It really leaves you pondering, doesn't it? How do we truly reconcile the inherent challenges fading memory, lost evidence, tactical trial decisions with the demand for accountability and justice decades after alleged events?